Hello and welcome viewers. You're watching the brand new show of Sansad TV on constitutional and statutory bodies. Each episode will spotlight a specific constitutional or statutory body in India, exploring its origin, structure, functions and significance in strengthening the country's democratic framework. Constitutional and statutory bodies are important in India because they ensure democratic functioning, uphold the rule of law and maintain checks and balances in governance. Constitutional bodies are established by the Constitution and have high autonomy, while statutory bodies are created by an act of Parliament to regulate specific sectors and protect citizens' rights. Together, they promote accountability, transparency and stability in the country's administration. The Constitution of a country is the fundamental law of governance. It guarantees dignified existence to all its citizens within the legal framework. We have had the benefit of a galaxy of visionaries who were definitive about the path we should chart out for ourselves and were fully conscious of the enormity of the task involved in drafting the Constitution for a newborn nation. The framers of the Constitution felt that certain policy directions, guidelines or instructions for the governance of the country were required to handle these problems. Legislatures, executive, judiciary and administration of independent India are expected to exercise their powers in accordance with the direction and guidelines given in the Constitution.
I propose to make this appeal. Let us leave aside slogans. Let us leave aside words which frighten people. Let us even make concession to the prejudices of our opponent. Bring them in so that they may willingly join with us on marching upon that road, which, as I said, if we walk long enough, must necessarily lead us to unity.
The Constitution of India provides for various constitutional bodies in India that play a pivotal role in the administration and ensure the smooth functioning of the democracy. Integral to the functioning of the democratic polity and governance in India, these bodies have a significant role in ensuring that the constitutional mandate is upheld and the country operates in the constitutional framework. But what is a constitutional body? Well, in the context of India, a constitutional body refers to an institution or authority that derives its powers and responsibilities directly from the Constitution of India. The Constitution either directly establishes these entities or mandates their creation, outlining their composition, powers, functions and duties. These bodies are explicitly mentioned in the Constitution, making them a fundamental part of country's governance and administrative structure. A constitutional body of India is also entrusted with performing specific functions to uphold democratic governance and ensure the effective implementation of constitutional mandates. But what is a statutory body? Well, these are non-constitutional bodies as they do not find any mention in the Constitution. They are also important bodies due to their function. They are created by an act of Parliament. These are also termed non-constitutional bodies that make rules and regulations and take decisions on behalf of the government. They are called statutory since statutes are laws made by the Parliament or the legislature. Since these bodies derive their power from statutes or laws made by the Parliament, they are known as statutory bodies. Let's take a look at the key differences between statutory body and constitutional body. Origin. Constitutional bodies are directly established by the Constitution of India. Their setting up is provided under certain articles of the Constitution. Statutory bodies are created through an act of Parliament or a state legislature. It does not originate from the Constitution itself but has its power based on legislation by the legislative bodies. Permanence. Constitutional bodies therefore are permanent and cannot easily be changed or dissolved. Any change in their form or function requires amendment by the Constitution, a rather complex and strenuous process. Statutory bodies are flexible and can be modified, dissolved, or reconstituted by amendment to the law or act that founded the body. Autonomy. Constitutional bodies are more autonomous. They have the protection of the Constitution, and their decisions and operations are even less prone to interference on part of the government. Statutory bodies differ in their level of autonomy. This is because it depends on the provision that the law presented for its establishment. Significance. Constitutional bodies form a fundamental function of the democratic and governance structure of the country. They perform activities such as elections, audits of the government finances, and recruitment of persons holding public service. Statutory bodies exist for some specified purposes or departments, like the regulation of the economy, enforcing human rights, or ensuring the regulation of higher education. Although important, their scope is very limited in comparison to constitutional bodies. In this episode, we'll delve into the office of the Attorney General for India, the nation's highest law officer, to understand the role, responsibilities, and importance in upholding the rule of law and guiding the government on legal matters. The Attorney General for India is a constitutional office established by Article 76 of the Indian Constitution, which defines the appointment, qualifications, and duties of the office. Appointed under Article 76 of the Indian Constitution, the Attorney General for India plays a crucial role in upholding the rule of law, guiding the government in legal matters and representing it in courts. In a democracy governed by the rule of law, the role of legal institutions becomes pivotal in maintaining a balance between power and justice. The Attorney General for India, as the chief legal advisor to the government and the top law officer of the country, occupies a unique space at the intersection of law, governance, and justice. The AG is expected to uphold constitutional morality by presenting the state in legal matters. The Attorney General is central to the legal arm of the state, helping ensure that the executive's action conform with the Constitution and established law. In a democracy like ours, where separation of powers is a guiding principle, the Attorney General functions as a key interface between the executive and the judiciary. Through careful legal interpretation, the Attorney General can influence major policy outcomes, especially in the areas like constitutional amendments, federal disputes, fundamental rights, and administrative actions. The Attorney General also plays a vital role in constitutional litigation, helping shape the evolving jurisprudence of India. Attorney General is appointed by the President on the advice of the government. The first Attorney General for India was M.C. Setawar at the time when India got independence. Let's take a look at the qualifications for Attorney General for India. He should be an Indian citizen. He must have either completed 5 years in High Court of any Indian state as a judge or 10 years in High Court as an advocate. He may be an eminent jurist too in the eye of the President.
Basic structure is, I think, will have to be part of our constitution and our national democratic fabric for a long time to come. Before our parliament and our governance systems internally, right, do not feel the need for breaking any frontiers and barriers. So to be internally feel, don't feel that need, and you're able to manage internally all these things. Till that time, basic structure doctrine must remain as part of a democratic framework. Have some very orthodox conventional views on the role of the courts. We talk from the separation of powers doctrine. Of course, it has to be seen from that angle. But I think whatever the Supreme Court or the higher courts are doing, right from 1950 onwards, the different trajectories which national development has followed, from a closed door economy to an open economy, an open society, and all those concomitant things which happen, I think courts are important in national development. If you look at from that angle, then I told even government and parliament can understand the role of courts in national development. I would like to put it as a role of the courts in national development within their own frontiers, which they will probably keep drawing, and so I don't think we should fall back into the conventional separation of powers doctrine. We need to look at it slightly differently. A more mature, structured way of debate about what courts should be doing, from understanding how it really functions. That's why I said we should look at it from a national development perspective. So if there is a importance about what, let's say, a free economy, right, and how do courts play a role in ensuring a free economy. And in a free economy, there are so many issues, right? Global participation, global resources, getting global resources, regulating them, entering into inter-territorial, inter-country treaties, so on and so forth. They're not an easy job, and therefore courts will understand them from that perspective. I would probably see the separation of powers doctrine itself moving into no dimension sooner or later.
Now let's take a look at the major constitutional provisions. Article 76. The President shall appoint a person who is qualified to be appointed a judge of the Supreme Court to be Attorney General for India. It shall be the duty of the Attorney General to give advice to the Government of India upon such legal matters. In the performance of his duties, the Attorney General shall have right of audience in all courts in the territory of India. The Attorney General shall also hold office during the pleasure of the President and shall receive such remuneration as the President may determine. Conduct of government business. Article 88. Right to speak and take part in the proceedings of either House, any joint sitting of the Houses or any committee of the Parliament. Article 105. That talks about powers, privileges and immunities of Attorney General.
I look at other examples of my predecessors who have done a great job in his office. People who have set excellent standards and examples, and who did not look at their personal aggrandizement or personal growth as part of being in the office, who looked at the office as mere service to the nation. So I look at that and then feel that, well, learn every day. Well, soon after my appointment came the demonetization case.
Right.
It was a wonderful preparation for me, and I'm glad the case was perceived the way government understood it, and I could persuade the court, I think, the way government understood it. So there were some tense moments while we were trying to convince the court, but that I think was the first and the most important entry into the office and handling a matter of constitutional importance, and which is economic, political, social implication. There are many other cases later, but of course Article 370, then recently the presidential reference case. Every case has their own peculiar context and importance, but some cases occupy your mind because you feel extremely delighted in doing them, right? Legal, jurisprudential challenges are different, but some cases stands out very differently.
But what is the role of Attorney General for India? Being the chief law officer of the country, the Attorney General for India has to perform important duties. Whichever legal matters are referred to him by the President, he advises the Union Government upon the same. President keeps on referring him or her legal matters that suits his or her interests, and the Attorney General has to advise on those too. Apart from what President refers, Attorney General also performs the duties mentioned in the Constitution. The three duties that are assigned to him by the President are: in any legal case where the Government of India is related to, the Attorney General has to appear in the Supreme Court on its behalf. He has to represent the Union Government in any reference made by the President to the Supreme Court under Article 143 of the Constitution. He also appears in the High Court if any case is related to Government of India. But what is the term of Attorney General's office? Well, there is no fixed term for the Attorney General for India. The Constitution mentions no specified tenure for Attorney General. Similarly, the Constitution also does not mention the procedure or any ground of his removal. He can be removed by President at any time. He can quit by submitting his resignation only to the President. Since he is appointed by the President on the advice of the Council of Ministers, conventionally he is removed when the Council is dissolved or replaced. Let's now take a closer look at the limitations placed on the Attorney General for India to understand the boundaries within which this esteemed office operates. Let's also take a look at the limitations that are placed on the Attorney General for India in order to avoid any complication or conflict in duty. He should not advise or hold a brief against the Government of India. He should not advise or hold a brief in cases in which he is called upon to advise or appear for Government of India. He should not defend accused persons in criminal prosecutions without the permission of Government of India. He should not accept any appointment as a director in any company or corporation without the permission of Government of India. He should not advise any ministry or department of the Government of India or any statutory organization or any public sector undertaking, unless a proposal or reference in this regard is received through the Ministry of Law and Justice or Department of Legal Affairs. Let's now explore the key differences between the Attorney General, the Solicitor General and the Advocate General to understand how these eminent legal officers serve a distinct yet complementary role in India's legal framework. The main difference is that the Attorney General and Solicitor General handle the legal affairs of the central government, while the Advocate General is the chief legal advisor for a specific state government. The Attorney General is the country's top law officer, while the Solicitor General is the second and the Advocate General is the highest within the respective states. The Solicitor General is the second highest law officer in the country after the Attorney General of India. The Attorney General is assisted by the Solicitor General of India and several additional Solicitors General of India for the fulfillment of his official responsibilities. The Solicitor General and the additional Solicitors of India also advise the Union Government and appear on behalf of the Union of India in the Supreme Court. The Attorney General of India is a constitutional authority entrusted with the critical task of advising the government, representing it in the court and defending its actions. As India's legal and constitutional challenges grow more complex, the Attorney General for India performs his duties fearlessly, impartially and independently, embodying the spirit of Constitution of India. Well, viewers, that's all we had for you in this edition. In the next episode, we'll talk about a new constitutional or statutory body and explore its role, powers and contribution to India's governance framework. Thanks for watching and stay tuned to Sansad TV. Goodbye for now from my side.
To watch more programs of Sansad TV, subscribe to our YouTube channel and don't forget to like and share them.